Dr. counsel was today acquitted and discharged. This has to do with the ambulance procurement trial. The fundamental question that we are asking tonight is, so has justice now been served? And as you know, this is the man of the moment, Dr. counsel. He's not the only individual who was discharged and acquitted today. He's become a household name now. He is Richard Jakpa. He's also walking free. And in fact, today, shortly after he had the decision of the appeals court, he made his way to the High Court to look for his passport. We asked him the question, are you planning to travel? He says, yes, he may travel because he needs to now go and look for more business because his livelihood had been shattered on the back of the trial that has been going on now for quite some time. 2 years, 7 months, and 7 days. He says his businesses have suffered over this period and he wants to re-engage now that he's a free man to get his life back on track. The Attorney General has been speaking, though. As far as he's concerned, this war is not over. He started this battle tonight. He lost the war, but he wants to start another one at the Supreme Court, and he's determined to get the Supreme Court, he says, to overturn what happened today. And the decision today was 2-1. Two judges decided that Atu Forcing and Richard Jakpa were indeed innocent of the charges against them. One judge dissented. So many lawyers, some may look at this and say, maybe the dissenting judge has thrown a lifeline to the Attorney General. Has he? We'll get into that when we sit to have a conversation with my panelists who are joining me. A few things that we learned today from the decision of the appeals court. And the two judges who felt Atu Forcing and Richard Jakpa were innocent, did not hold back. In tearing into the Attorney General's case, they made the point that the prosecution, they lacked sufficient evidence. And really, in court, it's all about the evidence. And if you lack that, and this is a criminal case, it goes way beyond the evidence. It's even the subject of reasonable doubt. And it appears in this case, it was just not reasonable. It was a huge chunk that will fill your entire mouth with doubts. The evidence wasn't there, at least the two judges believe so. And you have also the trial judges, and this in the case of the High Court. Remember, this matter here is on the back of the High Court judge ruling that Atu Forcing and Jakpa indeed had a case to answer. Their judges had gone before the judge at the High Court and said, there's no case for my client to answer, for these two clients to answer. And the judge disagreed with that particular position and went ahead to declare and rule that Dr. Atu Forcing and Richard Jakpa must proceed now to make their case. They disagreed, and so they went on appeal on the particular decision. That when they filed the submission of no case, they were convinced that they had a case, that indeed their case was that they had no case to answer. Tonight, the appeals court is clear that indeed had no case to answer. And so they made the point about the High Court judges ruling on the matter, and that it's really the trial judge erred when he asked Atu Forcing and Richard Jakpa to make a case. She should have dismissed the case at the time when they filed the submission of no case. Again, we saw those two judges of the appeals court say that the evidence was based on, and this is a really strong one, impermissible speculation. And it ties in, does it not, to the subject of no evidence. And again, that's a point that they make here that is really loud. And again, but fundamentally, remember, this is about ambulances, and this is about an issue of documents that were filed based on which the ambulances came to Ghana, the letters of credit. The two judges were clear in their mind that the Ministry of Health is responsible for this and not Dr. Atu Forcing. After all, he signed, if he did, the letters of credit. It was the Health Ministry's responsibility to inspect the ambulances and not his. And a very important point indeed that they also raised today. So, very important matters now before the court. He, in my shot there, the Attorney General, has a tall order. He will have to go to the Supreme Court. He said he will, and he's going to do so shortly, and convince the Supreme Court that he had a case all along and overturn what has happened at the appeals court. He's been speaking today too. And in his statement that was issued shortly after the decision was read, it was very clear, using some strong language, but the milder one, that the decision of the court goes against the rule of law. That was a position that he held. He also believed that the AG has a right to file an appeal, but he also described it as perverse, as erroneous, and grossly unfair to him. We've heard from the Ghana Bar Association today, and they're calling him out. They're criticizing the leader of the bar, and that is how serious this has become today. Because the spokesperson for the Ghana Bar Association, who was speaking the mind of the association, spoke to me on Top Story on radio and said, we, the bar, believe that the Attorney General's use of those strong words were unfortunate and that it is wrong. They called him out in no uncertain terms, that he should not be speaking the way he's speaking, considering that he's a leader of the bar, about a judgment that has gone against him. And they asked the question, if he had won, would he have used those same words to describe the court? And so he's been criticized by the association he's a leader of. That says quite a lot, does it not? And we'll get into that. But really, what did he say wrong? I mean, this is a case that has been decided. He says it's perverse. He says it is grossly unfair to him and that it was erroneous. What's wrong with that? Well, the Ghana Bar Association believes it was wrong for him to use those words, in that as a leader of the bar, he should not be seen denigrating the courts just because he lost the case. So that in itself is a significant part of the moving parts now that will become an issue going into tomorrow, considering rarely do you see the Ghana Bar Association calling out publicly a sitting Attorney General. But that's what has happened today. We'll get into that with my guest. Richard Jakpa himself has been speaking to us in court today on the back of this. And his point is very clear, that as far as he's concerned, there are still some judges in this country with integrity. And he's referring to these two judges of the Supreme Court. You know, he's had running battles with the High Court. So what really does this all mean for the High Court trial itself? From what we understand tonight, that has been truncated. The Attorney General says it is suspended. Why is he using those words? He's using that word because he's going to the Supreme Court. He's hoping the Supreme Court will overturn the appeals court judgment. Then that case can continue. But as we stand tonight, that High Court trial is dead in the water. But can it be resurrected? My guest will weigh in after this. Please stay with me. And thanks for staying with us here on PM Express. My guest is joining me right now, and PM Express is always brought to you by Syntex Tanks. It is strong, it is tough, and no matter your water needs, Syntex Tanks has it all. Syntex Tanks is first to introduce a double-layer tank, and now you can have as many layers as you want. And they're across the country. They also have bespoke 7 years warranty. Call them on 0244 335 168 or shop online at syntexgh.com. My guest joining me in the studio right now, a lawyer for the minority leader, Dr. Kate Selato-Forsing, Godwin Edigi Tamaklo, and he's in the studio with me. Also joining me is Alfred Tianyeboa, he's the Deputy Attorney General who joins us on the phone. Professor Kojo Pidgetia also joins us. He's Associate Professor, School of Law, also joins us with his thoughts on this. And Bobby Bansen is also a lawyer. And everybody else is poring over this because of how high profile it's been. And we're learning quite a bit more. And today, even the former President, John Dramani Mahama, has issued a statement on this. The Attorney General had said that they will promptly file an appeal at the Supreme Court. And I want to start with Alfred Tianyeboa on that. Mr. Tianyeboa, thanks for joining us here on PM Express. Do we know when the processes will be filed at the Supreme Court seeking to overturn the decision of the appeals court?
Thank you very much, my brother. And let me say good evening to my fellow panelists, especially Eduji, Prof, and then Bobby. Now, it's true that this afternoon we issued a statement indicating our intention to file an appeal. We are in the process. We have not filed it. We are still going through the judgment. And very soon it will be filed. And when it is filed, definitely the media will get to know about it.
Have you read the full judgment yet? I have it in front of me. I'm just wondering whether you've read it yet.
Yes, I have.
Using your legal brains, what will be the grounds for an appeal when you file?
All right. Maybe I'm not going to do the case on air, but just give some pointers. We think there are some fundamental flaws in the judgment, and these flaws have occasioned a grave miscarriage of justice, and that in our appeal, we'll be canvassing some errors of law that we think the appellate court erred on and urge the Supreme Court to overturn this judgment. So basically, there are various areas we're looking at, and when we file the appeal, definitely you will see the grounds for appeal that we will apply.
Okay, we'll interrogate that a bit more shortly, because there are principles around filing an appeal and the grounds that the court can use as a basis to determine whether that appeal will succeed or not. So we'll come to that, because I have Bobby Bansing and Professor Pejuchan who will help me unpack that for you. But let me come to the studio, and Edu G is with me. Edu G, congratulations are in order.
Yes, Evans, good evening. Good evening to your cherished viewers. In any case, I was led by my senior and my people master, Dr. Aziz Bamba, in this defense. So I want to thank him for the opportunity. That said, I want to also thank their lordships for the scholarship that they've demonstrated in this judgment. That said, I strongly believe, maybe I may want to start from the statement
Jakpa had made. By the way, how is Ato forcing?
I mean, he's in high spirit.
You talking to him since morning?
Yes. In fact, you know, immediately after court, then he heard that the majority were trying to smuggle in the vetting of the two Supreme Court nominees. So he had to rush to Parliament. And eventually some understanding happened. And so therefore, the vetting didn't take place. I understand it has been rescheduled for another day. He's in high spirit.
High spirit, celebrating,
admirably, all throughout this trial, he's demonstrated the strengths. And he's always maintained his innocence, that, look, from all indications, this trial was nothing but persecution. It was a hounding by Godfred Yebuadami, and the unfortunate part of it all is that right from the day myself, my senior, Dr. Dominic Ayeni, took the Honorable Counsel Ato Force into Yoko. I recall when we went to Yoko, we met the then executive director, deputy, Nanenchi. By the time we're done telling our story, he himself actually asked us to take the police statement home, go and write and bring it to him. Because he didn't even see. And so, Evans, what will shock you is that from November 2017, when we stepped into Yoko and left, they never called the Honorable Counsel Ato Forsen either to come and clarify any issue or whatever, until 25th November 2021, 6 days after the 2019, November 19, 2021 budget was read. And then the Honorable Ato Forsen opposed the introduction of e-levy. Then Godfred Yebuadami started the hounding. And so if you observe carefully, on 25th November, when we met the Yoko officials in the speaker's conference room, by December 22nd, Godfred Yebuadami, and he's such a coward, said that he will ask the DPP to sign the charge sheet whilst he continues the hounding of Ato Forsen. And look, when I read the statement that he issued, I felt so sad. I said, this guy cannot be the leader of the bar
But he was disagreeing with the decision of the appeals court. Which lawyers are allowed to do after the
we
decision of the
lawyers
court?
have an acceptable conduct, especially the leader of the bar. Maybe I can do that. But where the leader of the bar describes a judgment from the Court of Appeal as perverse, inimical to a so-called fight against abuse of office, what he's seeking to do is to incite the people against the court. And that should not be coming from the occupants of the revered position of the Attorney General. This guy should be resigning. Look, he talks of abuse. Curiously, this is an Attorney General who engages an accused person who had legal representation without his lawyer and encourages him, conspires with him, courts him to, as it were, implicate a fellow accused person in an ongoing trial. I have never seen a situation where a high court judge had cause to strongly advise him. This level of dishonorable conduct, I have never seen. Look, in my young age, I've seen Obed Asamoah as Attorney General. I saw even Nana Addo Dankwa Akufo-Addo as Attorney General. I saw my own company law lecturer, Joe Gatti, as AG, Marietta, and co. I've never seen them stoop this low just to get conviction against a political opponent for no wrong.
But he took your client through due process.
No. You see,
this is due process. If you suspect case of forcing of having committed a crime, you take him to a court of competent jurisdiction, which is exactly what he's done. And that same court has now said your man is innocent. The Attorney General hasn't done anything wrong, has he?
You see, where the Attorney General goes to the point of meeting an accused person, and first of all, anybody that has criminal charges against him is deemed vulnerable. And especially with the counts that can get you 10 years imprisonment, you are dealing with a vulnerable person. And so when an Attorney General, and per the professional etiquette rules, you are not permitted to deal with an accused person when that accused person is represented by a lawyer directly. You deal with him through his lawyer because of the vulnerable position he finds himself. On the 9th of April, 7 a.m., Mr. Godfrey Adame placed a call to Jakpa. What was he seeking to do? The Attorney General was telling Jakpa, okay, that go and procure a medical report and present it to a trial judge as though you are sick when you are not. I want to submit with your platform that this year's Ghana Bar Conference, the Attorney General is not worthy to speak to lawyers.
Why?
Look, first of all, even I've listened to the PRO of the Ghana Bar.
The bar, yeah.
Says the manner in which he reacted, the emotionally unintelligent response to the judgment is enough to disqualify him from speaking to the bar in this year's
He
bar
didn't
conference.
say exactly that. He
No,
criticized.
I am saying that.
The bar criticized.
Yes, but I'm saying that based on this, he had not demonstrated that he's fit and proper to address the bar at this year's bar conference.
And I'll bring Chiang, but there's something you said about his conduct. This was part of what the trial judge was had to evaluate when the mistrial processes were filed. She did not buy that argument. The worst she did was to advise him, which means she didn't find merit in that argument of mistrial based on the misconduct that you allege.
Do you know something? That is a view expressed by the judge. But Godfrey Adame had never denied to date that he never spoke to Rich Jakpa. In fact, if you look, even when the mistrial application was filed, he never mastered the courage to even file an affidavit to oppose it or deny that that was not his voice. He caused a state attorney to file an affidavit in opposition, that alone tells you the coward that he is. And you see, I take very, very, strong exception to the fact that, you see, you have a situation where you take my client through this ordeal, knowing well that there was no basis to put the Honorable Counsel Atuforsin before the court. There was no basis. And you see, may we never, and Evans, I say this, may no Ghanaian ever be put through this in the name of politics. It should never happen to any Ghanaian.
You've heard Chiayebwa, they're going to go to the Supreme Court. He believes they have the grounds to have this overturned. We'll come to that and expand on that a bit more. But I want to get...
Hold on.
I want to get his
just
thoughts
30 seconds,
quickly.
Can you
30
imagine,
seconds.
as at the time Godfrey Adame issued out his statement, he had not even read the judgment.
Yeah, but he knew what he wanted to do.
No, but you see, you are criticizing a judgment as being perverse that you have not read.
Yeah, but he disagrees with the
No, you can disagree.
Verdict, yes.
No, you can disagree and say, look, I will appeal. But you cannot describe the judgment as perverse. When you say something is perverse, what it means is that it does not accord with sound reasoning. It lacks logic.
Hold on.
Let me get you have not read.
Let me get you.
You
let me get you.
Say it is perverse.
And I'll bring profit.
Who does that?
I mean, the comments in the statement that was issued today has been criticized by the Ghana Bar Association. You've heard Eduji raise the point that should disqualify the Attorney General from speaking at the bar conference this year. What's your reaction to that?
I've listened to my brother Eduji. I dare say that the AG is nowhere near a difficult equation when it comes to the attendance of the bar conference. Unless and until something happens to make it impossible for him to be at a conference, he's going to be at this year's bar conference and will speak as the Attorney General of the Republic. Now, concerning the statement that was issued this afternoon, unless I'm convinced further, is it the case that because the statement was issued before the appeal of file, that's why we have a problem with it? Or it's about the language?
The language. The Bar Association had a problem with the language. Said that shouldn't be coming from the leader of the bar.
So, if we had filed the appeal, and in the appeal, one of the grounds, we had indicated that the judgment is perverse and cannot be supported by the evidence on record, would that be wrong? You say a judgment is erroneous or it's illogical in your grounds of appeal. Would that be wrong? My brother Eduji knows that when it comes to catching your notice of appeal and your grounds, you don't have to be insulted. It is considered. But you reserve the right to state your ground of appeal in no uncertain terms. At least you are straightforward to the point. The statement that was issued by the AG this afternoon, with all due respect, is a normal statement. He never attacked the judges in any way. If a judgment is rendered, and if you're making any public comment on that judgment, you may want to attack the judgment, but not the judge who delivered that judgment. This is a very simple statement, and the statement is to the effect that we are not in agreement with the judgment delivered by the Court of Appeal. And for that matter, we have been able to identify certain fundamental flaws which we see to be perverse, and will canvass those grounds at the Supreme Court.
But considering that the criticism is coming from the Ghana Bar Association, led by the Attorney General, that carries a bit of weight, does it not? That the bar itself is calling the Attorney General out. They believe he's wrong there.
The Bar Association may want to bring to the Attorney General's attention why they think certain words are wrong. That's the right of the GBA to do it.
Okay.
But that does not mean that when they say that it's wrong, it's obviously wrong.
Okay.
They may want to say, based on A, B, C, I'm here to be convinced. That's what I'm saying. I'm here to be convinced.
Okay.
If I don't obey, I'm convinced, and the A is also convinced that those words ought not to have been used, I mean, the honorable to be done. But as at now, I'm not convinced.
Please stay with me. Let me bring in Bobby Bansing and Professor Pejutia now into the conversation. Bobby Bansing, before we even go to the substance of what the grounds of an appeal normally should be before a Supreme Court can consider it, and whether this passes that particular test, give me your quick comment on the issue now in context. To hear the Ghana Bar Association criticizing publicly an Attorney General, a sitting Attorney General, I had to go way back in history to try and find one, and I've struggled to. What's your comment on that? Do you agree with the bar, or you agree with the Attorney General that this is nothing and he was just expressing his view on a very, very bad judgment?
Opinion. I don't think that the Bar Association erred when they decided to issue that statement. As a body that is recognized, has that standing in the society that is expected to comment on some of these happenings within our legal space, I do not think I'll fault them. To a large extent, perhaps I wouldn't have used the words that the Attorney General used to describe the judgment because of who he was, his position. Eduji said perhaps if he, not being the leader of the bar, had used those words, or somebody not being the leader of the bar had used those words, you would have, should I say, pardonable, for lack of a better word. But looking at the status of the Attorney General, the impact that his statements, his actions would have, not only on the bar alone, but also law students, people that are aspiring to this education, the relationship between the bar and the bench, and the role that he plays in maybe the choice of words. He may not have meant wrong, but you have to face it. If you use a word like perverse against a judgment, perverse could connote an intention to move away from what is right. It connotes that there is an agenda, for lack of a better word, not to do what is right. Somebody may interpret it like that. And so you will not fault I would not fault the Ghana Bar Association for commenting the way they did. And as the Deputy Attorney General has said, maybe they didn't mean bad. They just meant to say that the judgment was against the weight of the evidence and was unreasonable, which for the grounds of appeal in a criminal matter is allowed. You can use the sentence that the judgment is unreasonable considering the evidence that was adduced. It's allowed. But, the moment you add the word perverse, in the mind of the ordinary person, which most of Ghanaians are, maybe as a term of art, lawyers may appreciate it, but to the ordinary mind, it may connote something strong, which perhaps the Attorney General, with hindsight, should not have used those words.
Let's attack the substance now. I mean, where we are tonight is the Attorney General telling us that he's going to go on appeal. And Bobby, I know Professor Pejutian's opinion on this because I spoke to him earlier on the subject of the words Attorney General used. Bobby, let me pick your thought very briefly. First of all, give me your very quick reaction to the decision of the appeals court, knowing what you know about the case that had traveled for more than 2.5 years.
I have read the 125-page decision. I think that both sides gave a very reasoned opinion on what they are. If you go through the decision, almost all the judges used the same cases, the same principles of law. It's the application to the evidence that had been led that resulted in different conclusions. You would see that even though it's a criminal matter, there were a lot of discussions on what we think are the rules on appeal or evidence in civil proceedings, but they were being borrowed into criminal proceedings. I mean, as somebody who is interested in developing the frontiers of the law, only on that score, I would be interested in what the Supreme Court would have to say on this matter. And so I'll be happy if the Attorney General files an appeal. But Evans, it's in most of the narratives, you seems to suggest that this matter is quite degenerating into being a substance of, okay, has somebody allegedly done something against the state for which the state, without any malice, is seeking to prosecute the person, into something as if the Attorney General has a personal vendetta or agenda against the accused person. And if you hear Eduji speak, he speaks from a place of passion. And I won't fault him because as a counsel in the matter, maybe he's aware of some facts that will not come to bear. And I think the Attorney General's office, and I hope that my senior Etia would be able to speak to this, so that it is not as if in the minds of the public, there is a personal agenda by the Attorney General to, by all means, for whatever purposes, use the state resources to persecute, let me put it that way, the accused person. I think that it is important for the Attorney General's office to speak to these facts. Otherwise, it will shroud whatever prosecution that is being conducted, and it will not be good. Looking at the office, the personalities involved, and then the image as a country that would be projected out there if the narration keeps being degenerated from the rule of law, the substance. I read the judgment and I was happy because there were areas of law that you could see Justice Akabuafo, especially when it comes to burden of proof. At what point do you say it has shifted? And then when you come to the analysis by Justice Pokwe Champon, how he saw it. And so those, for me, as a student of law, I was very interested in how they applied the same principles of law to the same facts, but yet, got to different conclusions. And we'll be happy to see how the Supreme Court develops this. But the more the discussion is narrowed down to the intention, as if there is malice, I hope the Attorney General speaks to these matters so that it clears the minds that listen. We just want to do our best, whether or not that could be accepted or not. It's up to those involved.
And Prof. Chai, but when we spoke at 5:30, we were all waiting to look at the judgment. I don't know if you've had time to scan through it, but now that we're learning a bit more about what the judges actually said to back their positions, where do you stand on whether this case has been decided by the appeals court, has grounds in there for appeal of the Supreme Court? Hello, Prof.
Okay. You said Prof.
Yes, Prof. Prof, yes.
Okay. Yes. Personally, I haven't had time to read the full judgment.
Yep.
But from the little that I read, it sounds interesting. And I think because of the way the judgment went, especially looking at Justice Akabuafo's judgment, which I read a large part of, I think that interesting issues are coming up. So calling for an appeal may not be a bad thing, so that you'll be able to, at the end of the day, see how the law develops in that direction. Having said that, I also think that there have been a lot of situations or circumstances or some remarks and positions taken by the Attorney General, which seems to deviate from in some respects, ethical standards and professional standards, which therefore doesn't create the impression of he being, if you like, a neutral person, but in some way having overly involved himself in the case as a way for which therefore lends room for people to speculate or conclude that he seems to have a personal vendetta in the matter. So I think that looking at how these plea bargaining issues went about, looking at what the judge said in the High Court about advising him to recuse himself, and even this statement issued after the judgment was read today, I think that the use of the word perverse was a little bit too strong. And so there seems to be some sort of political vendetta in the whole scenario. But I think we should let the case go to the Supreme Court, and then at the end of the day, we see how everything will be decided. Yeah, so that, but if it is just a case of ensuring that we get to know something new about the law, a situation where the jurisprudence of on that subject matter will be enhanced, it is a good thing. But if, on the other hand, the Attorney General is on that personal vendetta, or in a situation where there's some fixation on ensuring that on political grounds or some other reason somebody is imprisoned or found guilty of causing financial loss to the state, then my view is that we better let the case rest here after the Court of Appeal decision, so that the resources can be used for many other cases that the Attorney General's office has, and to ensure that life can go on and we'll be able to deal with other matters that are also of importance to improving the criminal justice system in the country.
I mean, thankfully, the Deputy Attorney General is on. Let me put that question to him. Alfred Chinyeboa, is the Attorney General, yourself and your boss, are you on the personal vendetta here? And that the Supreme Court path you're charting is all in furtherance of this agenda?
Not at all. I have been with the Attorney General for at least 3.5 years. And I know as a fact that he has no personal interest in this particular matter. This is a matter that has been prosecuted by officers of the state, including the Learned Attorney General. We are aware that if a matter is taken to court, it does not automatically mean that you are going to win your case. As lawyers, we are also aware that when you are prosecuting a criminal matter, it's either you have a conviction or an acquittal. And so if a decision is made, and upon assessing the decision, as prosecutors, we think that there's a need for a higher court. In this case, the Supreme Court will also have a look at it. I mean, that's how the law goes. It doesn't mean that we just matter take the Supreme Court by all means. It's because we say they agree with us. No. But we will make our legal arguments. The accused person will also make their legal arguments. And the Supreme Court, as we know, will come to determination on the matter. So the Learned Attorney General has no personal interest in this matter, has no problem against any of the accused person, whether it's the Honorable Minority Leader or Richard Jakpa. Rather, unfortunately, he has been the subject of attacks. Almost every time when this matter comes up and our friends on the other side are commenting, they use the word persecution. I mean, this matter is not being prosecuted by the Attorney General alone. At times, I do. Other times, the DPP also comes in. On other occasions, you have other key state attorneys. With all due respect, these officers of the state are non-political persons, apart from my good self, the Attorney General, and my colleague, Deputy Attorney General. So are you also saying that the other officers of the state also prosecuted?
They act under the instructions of yourself, the Attorney General, and your other deputy, who are all political appointees. They take instructions directly from you.
They take instructions, but they are also lawyers in their own right. And they will not take any wrongful or unlawful instruction. You may want to instruct them, but you must make sure that the instructions you are giving them are instructions that you can defend. Otherwise, do not take it, because they're also lawyers in their own right. So prosecuting the matter does not mean that the prosecutor has a personal interest in the matter. We are only prosecuting the matter because, from our point of view, there's sufficient evidence to warrant that prosecution. We may be wrong, but we cannot determine it. It is the duty of the court to determine whether we are wrong or right. And in this case, today, the Court of Appeal said they think that this matter must end because the accused persons have been acquitted. Fair enough. We also have the right to say, fine, we are not so convinced. We think this matter must be looked at once again by the Supreme Court. Supreme Court is the final court of the land. We go there, you may either be vindicated or our case will be thrown out. We are mindful of that fact.
I mean, Professor Bejetia, quickly on this. That's the fact that you have a dissenting judge throw a massive lifeline to the Attorney General at the Supreme Court.
Not really, because every judge will examine the case independently. Of course, at a point, they may discuss some issues relating to it. But each judge determines the matter on his own, unless they decide that one person writes the opinion. And so, in that respect, I'm not sure it can make any difference in terms of whether it will advantage the Attorney General or throw in a lifeline for him in the case.
I mean, Bobby, this wasn't unanimous. If it was unanimous, wouldn't this have been fait accompli and possibly would have convinced the Attorney General that there's no point taking this up out of the Supreme Court? But because it's not, there's an opening there, you know, that strengthens his case to go to the Supreme Court.
Evans, in practice, it really doesn't work like that. You could have a unanimous decision by the Court of Appeal that is completely overturned by the Supreme Court. Remember, an appeal is by way of rehearing. Rehearing meaning that the court exercising appellate jurisdiction would have to look at the whole evidence that was led without prejudice to the decision that is being appealed against. So as the prof said, they will be independent and they have a look at it, whether there was dissenting, whether it was unanimous. It really does not make any difference. The most important thing is whether you be able to convince them that if there is a second look at the evidence with the application to the facts and the law, the conclusions that the courts, either at first instance or second instance, arrived at will not be maintainable or cannot be defended by the appellate court.
Interesting points there. And Energy, so this is going to the Supreme Court. You've heard the Attorney General Deputy disagree that this is they're on this vendetta, an agenda to get, I know you're not convinced by that, but this will come down to what the Supreme Court says. You have any faith that the Supreme Court, this position that's been articulated by the Appeals Court will hold?
I have always believed in the innocence of my clients. Whether Supreme Court Antwa Nogokpo, my client is innocent. It matters not. So Godfrey Yebu-Adame can do whatever he wants. I want to repeat, you don't expect my senior Tua Yebua to say his boss is up to a vendetta. You don't. So I was even surprised you asked him that question. You understand? I was so surprised you asked him that question. What is not in doubt is that, look, Godfrey Yebu-Adame, in the House of Justice Yoni Kulendi, with Richard Jakpa, maintained that the president and the finance minister there were on him to get Atuforsin down. That has not been denied by him. In fact, in the House of Justice Yoni Kulendi, Justice Yoni Kulendi, called Jakpa and gave the phone to Godfrey Yebu-Adame for 17 minutes.
Is it before the court, at the High Court, in the process
Richard Jakpa had
mistrial?
Richard Jakpa had, no, after the mistrial. All these points had been made. I am saying that when the audio recording, Godfrey Yebu-Adame never denied that that was not his voice. You understand? So when you have an Attorney General proceed in the manner in which Godfrey Yebu-Adame did, consulting with an accused, a vulnerable accused person, to implicate a fellow accused person, just to get a conviction at all costs, that is not the work of a prosecutor. That is the work of a persecutor.
How is this important to the substance of the matter that may go before the Supreme Court, though?
No, the point I am making is that at all material time, what Godfrey Yebu-Adame has set out to do is to destroy the honorable case Atuforsin. Nothing more, nothing else. And so whether he is going to Supreme Court, Antwa or Nogokpo, it is that self-hate, it is that self-vendetta against the person of honorable Atuforsin. That is what is driving him. Our Attorney General at this point is going through an emotional crisis.
Then you should be happy that he's using the due process then, because the courts won't allow him to do that.
Please don't confuse what he's doing with due process.
But that's what he's using,
I
isn't
beg you,
it?
I beg you.
How do you separate the two then? He's in court.
You see.
He's not taken to a tribunal set up by the president.
A person can disguise his intention by applying what appears to be due process, right? To run a personal vendetta against an individual who has not wronged him, but purely politics.
But you have faith in the courts that if indeed that's what he's doing,
in fact,
he'll be found out, like the appeals scored at.
First of all, if we've never had faith, right, we would not even have appealed the decision from the trial court, right? What I am saying is that in a very extraordinary manner, the trial court proceeded. Curiously, I find a bit curious the response of Mr. Godfrey Adame relative to this matter. You know, in the opening trial, after the trial court judge gave the indication that he was going to start de novo, my Lord Justice Anochi, Godfrey Adame appealed that decision, right? When he appealed the decision to the Court of Appeal, Koram Bright Mensah, who incidentally is here, Jennifer Darcy, Justice Jakpa, they overturned the decision of Anochi Jima for the trial to continue where Justice Onyenuga left off. It wasn't perverse. It wasn't unreasonable because he was happy. Is that the point? Is that the point? When her lady judge, the trial court judge, ordered us to open our defense, what we did was quietly file our notice of appeal. And in fact, if you look at our ground H, which was reproduced in this judgment, if you look at our ground H, it simply says the ruling of the court is unreasonable, having regards to the evidence. Simple. Did you even hear that we have appealed the decision? Why the grandstanding by the Attorney General? I am telling you that this Attorney General cannot understand why the court should rule against him. Who the hell does he think he is, respectfully?
No, but he's entitled to go to the Supreme Court.
But
what has he said?
You say in the manner. I am just saying that we are parties in this matter.
Yeah.
When the High Court, when we did a submission of no case, and the High Court judge took the view that we had a case to answer and that a prima facie case has been established, quietly we filed our notice of appeal. Did we issue the statement that we're going to appeal the decision of the trial court judge? No. Why the grandstanding? Is to feed a particular narrative. And if you read the statement, the concluding part of the statement, the last paragraph, extremely offensive.
True.
The court and terribly prejudices even the accused person. What does Godfrey Adame mean when he suggests that it is inimical to the fight against abuse? If we are talking about abuse...
But that's his view, that your client abuse...
So I'm coming. If we are talking about abuse of office, look at Godfrey Adame's own conduct of reaching out to Richard Jakpa, the privileged position of an Attorney General, the principal prosecutor of this republic, reaching out to an accused, a vulnerable accused person. Is that conduct good or demonstrate further abuse of power?
I mean, and it's curious you raised this. You started raising this at the beginning. If you believe what you're saying, there are procedures and processes to challenge Attorney General.
Why?
I haven't seen any...
No.
I haven't seen any movement on that.
Relax.
Because you feel very passionate about it.
Relax.
The processes are there. Would that happen?
Relax. It's a very long journey. Let's see how the coming days will be.
You are hinting at federal action that you'll be taking.
Let's see how the coming days will be. Look, like I told you, Godfrey Adame spoke to Richard Jakpa on Justice Yoni Kulendi's phone for 17 minutes. He has not denied that. Let's see what the coming days will be.
What would it be?
Let's see tomorrow.
Well, gentlemen, this is a case that, as we know, the Supreme Court may have to decide it finally, and the Attorney General has indicated the same. They'll be filing. Professor Apejetia and Bobby Bansi, I'm grateful that you joined us with your thoughts on this. Also, Alfred Chiayeboa, enjoy the rest of your evening.